Hello, everybody. Dave Neal here, and we have some entertainment news to share with you. An update to the Ed Sheeran lawsuit, found not liable in Marvin Gaye copyright trial. This news just came out, and we're going to discuss it right now. Ed Sheeran was on trial for several notes and harmonies that were said to be the same from Marvin Gaye's song "Let's Get It On," and Ed Sheeran did just that, and he won the trial. Have a listen to what he had to say.
I'm obviously very happy with the outcome of the case, and it looks like I'm not having to retire from my day job after all. But at the same time, I'm unbelievably frustrated that baseless claims like this are allowed to go to court at all.
Yeah, he was sued for $100 million.
We've spent the last 8 years talking about 2 songs with dramatically different lyrics, melodies, and 4 chords which are also different and used by songwriters every day all over the world. These chords are common building blocks which were used to create music long before Let's Get It On was written, and will be used to make music long after we are all gone. They are in a songwriter's alphabet, our toolkit, and should be there for all of us to use. No one owns them, or the way they are played, in the same way that nobody owns the colour blue. Unfortunately, unfounded claims like this are being fueled by individuals who are offered as music experts in musical analysis. In this instant, the other side's musicologists left out words and notes, presented simple and different pitches as melody, and by doing so, created what I think we proved for all to see were misleading comparisons and disinformation to find supposed similarities where none exist.
So there's the idea of musicology, right, is the study of notes and progressions and all these different things, and they're used to decide whether or not one song was ripped off from another. Well, in order to prove his case, Ed Sheeran literally gets his guitar out in the trial and shows his creative thought process here.
And I think we proved for all to see that they tried to manipulate my and Amy's song to try and convince the jury that they had a genuine claim. I'm very grateful that the jury saw through those attempts. This seems so dangerous to me, both potential claimants who may be convinced to bring a bogus claim, as well as those songwriters facing them. It's simply wrong. By stopping this practice, we can also properly support genuine music copyright claims, so legitimate claims are rightly heard and resolved. If the jury had decided this matter the other way, we might as well say goodbye to the creative freedom of songwriters. We need to be able to write our original music and engage in independent creation without worrying at every step of the way that such creativity will be wrongly called into question. Like artists everywhere, Amy and I work hard to independently create songs which are often based around real-life personal experience. It's devastating to be accused of stealing someone else's song when we've put so much work into our livelihoods. I'm just a guy with a guitar who loves writing music for people to enjoy. I am not and will never allow myself to be a piggy bank for anyone to shake.
Wow.
Having to be in New York for this trial has meant that I've missed being with my family at my grandmother's funeral in Ireland, and I will never get that time back. These trials take a significant toll on everyone involved, including Catherine. I want to thank the jury for making the decision that will help protect the creative process of songwriters here in the United States and all around the world. I also want to thank my team, these guys, who've supported me throughout this difficult process, and to all the songwriters, musicians and fans who've reached out with messages of support over the last few weeks. And finally, I would like to thank Amy. Neither of us ever expected that 9 years ago, from our wonderful writing session, that we will be here having to defend our integrity. Amy, I feel so lucky to have you in my life. Thank you. We need songwriters and the wider community to come together and bring back common sense. These claims need to be stopped so the creative process can carry on and we can all go back to making music. And at the same time, we absolutely need trusted individuals, real experts, who help support the process of protecting copyright. Thank you.
I mean, amazing stuff here, and it's very fascinating. You know, this affects so much creativity. Imagine if he was found guilty of ripping off another song. So you create hot cross buns, and then someone else uses those same 3 notes in a different song. Now, there are legit issues that should be attended to when it does come to copyright in thievery in art, and this clearly, as the jury showed, was not one of them. So criminal Ed Sheeran slams musicology expert in thinking out loud copyright trial. So here's what Law and Crime Network had to say about what a musicologist is. And as we know, when it comes to trials, you find an expert who's going to side with you, and you can have an expert side with the defendant and a different expert side with the plaintiff and so forth. And, you know, it really can take into credibility who these experts are. It almost makes you, wonder, is there a sort of way to review it, whether or not someone is a musicologist, if they are blatantly misinterpreting what is very obviously not a copyright issue because there's money on the line.
Musicology. The plaintiffs hired a musicologist to testify about the similarities of the songs. You see, it can be hard to parse out the similar chord progressions when you hear the two songs played, but once you break them down into their individual parts, it is easier to understand. Musicologists can be called as expert witnesses to talk about the music industry as a whole, as well as issues like licensing, co-writing, using a song for parody. Judith Fennell is a forensic musicologist who testified on behalf of the plaintiffs in the Blurred Lines lawsuit several years ago. You might remember this one. Marvin Gaye's estate had sued Robin Thicke and Pharrell Williams, saying that Blurred Lines copied Gaye's hit Gotta Give It Up. Thicke, Williams, they lost. They were ordered to pay $5 million plus half of any future royalties for that song. Big judgment there. Well, we sat down with Judith Fennell to get her take on what's going on with the civil case filed by Catherine Townsend and how it's similar to that landmark Blurred Lines case. Plus, in the end, what will really be the outcome and what's it going to be based on?
So this was obviously 2 days ago, so they didn't know the outcome, but just goes to show that Marvin Gaye's estate already won a lawsuit. And again, there are probably plenty of times when, like with Blurred Lines, where they can prove that this was stolen from us. So, maybe they just got a little too confident.
In the end, though, if there's a lawsuit, the lay listener is the eventual judge and jury, if you will. Meaning that the untrained listener, your average juror who has probably little or no musical background, is making a decision based on really that particular person's or that group of people, their perception of what they're hearing. And as I say, in this case, the present case, as well as the earlier case involving Marvin Gaye's music, the recording by Marvin Gaye is not being permitted, I believe. It's based on the copyright that protects only what you call the composition. So it's only what is called a lead sheet that was submitted for copyright.
All right, so clearly, but look, they're almost making it sound like an untrained they say untrained listeners will make the decision, but that's what a jury is. A jury of our peers. You educate them onto, whatever psychological issues might be happening in the case. In this instance, it's the musicology of how notes can be manipulated or changed in a way, like what's original versus what isn't. It's almost like, well, we all speak. If you're writing a song in English, you can steal words that were previously used, but not in certain orders. Like, you probably can't say "Let's Get It On" and sing it with the same beat and then make money off of it, because obviously you have to have a protection there. But if things have been changed to a certain degree, then you of course are able to use that as an original thing. But it's not the first time Taylor Swift's "Shake It Off" copyright lawsuit was dropped. She had an issue go on for years as well. Of course, there's all these people that are worth. It's the top stars that are targets here. Taylor Swift has shaken off a copyright lawsuit that alleged she had plagiarized the lead song in her 1989 album. So in Taylor's instance, it's plagiarism. Versus in Ed Sheeran's, it was the actual musicology of the notes. Two songwriters, Sean Hall and Nathan Butler, dropped the suit and said they would dismiss the case with prejudice, meaning that they will not be able to refile, according to Reuters. A trial for the case had originally been scheduled to start in January. The court papers filed on Monday did not state if there was a settlement. So maybe she gave him a few bucks to shake it off. Either way, it was a very interesting claim that happened here. And again, we see this a lot in stand-up comedy, where you'll have one comic make a bit that's so similar to another's, and it's like, look, there's only so many words in the dictionary, and there's only so many opinions, that there's a certain thing called a sort of like a parallel thinking is what it's called, and that could be happening right here. Either way, I thought this was an interesting story to talk about. Let me know your thoughts if you have any, and we'll be back tomorrow with more content. If you want some more for your drive home today, check out Bachelor Rush Hour, our hit entertainment news podcast. We have a Vanderpump Rules recap there, and some American Idol original music, and we talk a little bit about Love is Blind and Bachelorette. All right, folks, we'll be back tomorrow with more content. We'll talk to you then.